Good day. People ask me all the time about the eviction process in Philadelphia, so I figure it'll be easier to make a video as opposed to explaining to it every time I get asked. So let's just start off with, you need to be in compliance. Before you even begin to start the eviction process, before you even think about starting the eviction process, you need to be in compliance. I explained that in a different video, so I'm not going to go over it again right now. Let's just say you are in compliance for the sake of this video, and a tenant's late. So what do? The first thing you can do, and I'm not going to talk about collection best practices. I'm just going to talk about the legal procedure of eviction. So the first thing is you need to send your notice to quit or your 10-day notice. You can send this by mail. You can send it by email. It doesn't necessarily have to be certified mail. After that, in Philadelphia, you have to file for the mandatory eviction diversion mediation. This is a process where the tenant gets assigned a mediator and a housing counselor. They're going to reach out to the tenant. You also have to reach out to the tenant and send them the information in writing, either by mail or email. They are going to attempt to try to get the tenant to cooperate, to agree to a mediation hearing, conference call, whatever you want to call it. At that, let's assume for now that the tenant does not cooperate. If the tenant does not cooperate, they are going to send you, after 30 days, a letter that the tenant didn't cooperate, that you cooperated in good faith. At that point, you can actually file for a court hearing. The eviction diversion mediation process can be done by you, by your property manager, by the eviction attorney. That's up to you. But let's say we're here in the process. You can file for a court date. You'll get a court date depending on the schedule of the court, usually within a few weeks from the time you file it. At that point, you'll have your first hearing. If the tenant does not show up to the first hearing, they don't show up and you do show up, that's an automatic victory for you. You get a judgment. Great. Let's assume the tenant does show up. If the tenant does show up, then assuming they know anything or they get an attorney, they are going to ask for a 30-day continuance. And they're going to get it. It doesn't make a difference the reason. They don't need a good reason. They don't need any reason. Can I have a 30-day continuance? The answer is 100% of the time, yes. At that point, it's really not a real 30 days. It's typically about 5 weeks. Then you go back 5 weeks later, you're at the hearing. So most cases do not go in front of a judge. Probably 1%, 2%, less than 10% probably do. Most cases get dealt with on an agreement. You go into the hallway at landlord-tenant court, or your lawyer talks to their lawyer, and you come up with what's called a judgment by agreement. Within the judgment by agreement, it's a negotiated, it's a negotiation based on what terms that you both can agree upon. If you cannot agree, it goes in front of the judge. When it's always, you never know what a judge is going to do. So it's always recommended to try to get a judgment by agreement rather than go in front of a judge, because a judge could do anything. You may feel 100% confident that your case is correct, and a judge may rule against you because they may interpret the law differently, or they just may feel a certain way. They may feel bad for the tenant, and even if they feel bad for the tenant, even if you're 100% correct, you may not get your way. So let's say you either get a judgment or a judgment by agreement. If you have a judgment by agreement, the tenant has to live up to the terms of the judgment by agreement. So do you. If the judgment by agreement calls upon for you to do something, like fix something or something like that. But let's say, so assuming they do live up to the terms of the judgment by agreement, they will, it'll just keep on keeping on, and the eviction process really ends at that point. You have a judgment against them. But let's say they don't live up to the terms of the judgment by agreement, or you got a judgment in the first place, they didn't show up, or that you just went in front of the judge and you won. At that point, there is a 10-day appeal period to a judgment, not a judgment by agreement. After that, you can file for the sheriff's lockout. Depending on how busy or not busy the sheriff is, that can take anywhere from 30 to 90 days. At that point, there'll be a lockout scheduled. The tenant can appeal at any point during this for any number of reasons, which could cause delays, and possibly a loss case if the tenant's correct. Anyway, so you'll get a notice that the lockout's scheduled. You'll need to have a locksmith there that day. You'll need to secure the property. At that point, the tenant has 30 days to get their stuff. You can't throw out their stuff for 30 days. You can move it to storage, but you can't throw anything out. After that 30-day process, then you're finally done. The process is yours. Depending on what the tenant does, it could be several months to 9 months. It could even be longer, depending on what the situation is. But let's go back to the mediation hearing. At the mediation hearing, the tenant will again get assigned a housing counselor and a mediator. The mediator's job is to try to come up with some sort of compromise, some sort of agreement where you both can live together. Assuming that happens, then again, it's the same thing. You have you have an agreement, and hopefully they live up to their end of the bargain, and you're up to your end of the bargain, and it continues. There's also an opportunity for the tenant to get targeted financial assistance, which at this point is up to $3,500 plus 2 months rent. You can only get that once. So once you get TFA or targeted financial assistance, if the tenant falls behind again, they're ineligible to get it again. Also, if you file for eviction, the tenant becomes ineligible. So if you do have the 30-day mediation period, and let's say you either cannot come into agreement or the tenant doesn't cooperate, and they've never gotten financial assistance before, you need to decide whether you want to file in court or not, and the ramifications are that you become ineligible for targeted financial assistance if you do file. So you really have to use your judgment based on what you know about the tenant. Targeted financial assistance is only available for tenants that qualify and cooperate. Qualification is pretty easy. It's an income loss. Chances are, if they didn't lose their income, they'd pay their rent, unless they're crazy. But it's really up to cooperation. You have to assume that you have to guess whether the tenant has it together to cooperate with with targeted financial assistance. So this is the basic process. There's a few other twists and turns to it, but this is the gist of it. For any questions about compliance, see my other video. The legal costs really depend on what happens, how many hearings, whether there are appeals, whether you get a JBA, whether the tenant moves out as part of the JBA, whether you have to file for the actual lockout or not. So the cost can vary. I hope this helps, and have a great day, and good luck collecting rent.